Ah, fantastic. So welcome to today's session. Today is April the 20th and it is 11:30-ish. And we are at our small business and notary networking event. We are covering estate planning, leveraging your legacy or the legacy of your customers, depending on your role. Some announcements. So most of you are here
Oh,
because
thank you. Okay, you
hold
too.
on. Let me go ahead and mute everybody. Give me 1 second. All right, I'm muting everybody just in case you need to speak. Just go ahead and turn your mic on when you need it. So some quick announcements. Some of you are here because you are part of Facebook group. Hopefully, hello everybody. Hopefully, if you are not, I will be sending all of this information out in a email. So if you are not, please go ahead and sign up. You will get a lot of free information in that Facebook group. And of course, you are here because you definitely signed up for today's session. So there are 6 months in advance. I'm working on the next 6 months of our business calendar. Our next session is actually focused on taxes. So this is Mary Lacusa, and she is ABC Consulting, and she is going to focus on helping us make sure that we are prepared for our taxes, because I had to pay this year and I don't want to do that next year. So that's one of the things we're going to be talking about. I think what I'm going to do is on this section, I do love to hear who's here and who you are, and I want to give you that time and that space. But because we do have a lot of questions, I might leave this to the end. So if you have any questions, introduce yourself, your company, your passion and your motivation. And also, if you would like to be interviewed, let me know, because I'm trying to start a series of interviews of people just like us who've opened up these little businesses and like what it is that you do and why you do it. But for now, for the sake of time, I want to go ahead and get into like the nitty gritty, the meat and bones of why we're here. So of course, we're working with lawyers and notaries, right? We love our disclaimers. So our disclaimer is super, super important. Again, I am going to be sending all of this to you so that you can read it for yourself. But basically, we are not giving legal advice during our session. We are answering information, and everything is not a one size fits all. So if there's a situation that you need to speak to Bryce, do you want to be called Bryce, or do you want to be called, what would you like us to call you?
Bryce is just fine. Yeah.
All right, so if you have some specific questions that you want to ask Bryce that have to do with like actual legal matters, please contact him separately. This is just an information source for today. Sorry, my mouse went the other way. Let's go the other way. All right, so I don't know why the mouse is going all over the place. Let me move my little screen so I can see. The disclaimer is really important because we've now shown it 3 times. So for today's objectives, we're going to kind of get a good understanding of what estate planning actually is. And hopefully at the end of the session, we'll have some insights. Not only, for example, I am going to have an estate planning party, if you will. So I have another notary and her husband, and me and my husband, and we invited another notary and her husband, and we're going to have an estate planning party. So the information that I'm using today, I'm going to hopefully be able to use when I actually start creating my own estate planning. So not only will you be able to gain those insights on best practices, but hopefully success tips, not only in your personal life, but I know the majority of us here are notaries. So hopefully we'll help you with that too. So because we do have about 14 to 15 questions, and we have maybe 10 of you in here, what we're going to do for the sake of time, like I said earlier, I do want to give you the time to introduce yourself and your company and what you're doing and why you're here, but we're going to save all of those to the end. So in order to do that, do any of you know what a parking lot is? Do we know what a parking lot is? A parking lot, for those of you that don't know, is a place where you can put your questions, right? So normally these are in a face-to-face training, and it's like a physical piece of paper that you would put your parking lot questions for, because either the presenter didn't have time to answer the questions, or possibly they set up in a way where it's kind of like, we're going to dump some information at you and then give you some time to think about those questions towards the end. So because our session is kind of jam-packed with questions, we want to give Bryce as much time as possible in order to answer the questions and then give you time at the end, okay? So what I did is I created this note-taking guide. So we're going to go question by question. If, for example, Bryce says something like, I don't know, whatever, you can ask, question on, and then you can fill that in, right? Or you can use it as a note-taking guide. So if there was like a burning question that you had related to the topic itself and it gave you the answer, here is the perfect place to put it, right? Blue versus black ink is an example. So what's going to happen is when you click on the link in the chat box, it's going to force you to make a copy in your Google Drive. So you're not editing the document that I gave you, you're creating one for yourself. So if any of you have any questions on forcing that document, it's literally called a forced copy. Just let me know. If you don't have time, just grab a piece of paper and start writing in your own piece of paper, okay? But you will have access to all of these things at the end of today's session. So let me go ahead and start with the presentation again. I just kind of wanted to show you what a forced copy note-taking guide looked like for today's session. And now I'm going to pass it over to Bryce. So if you can see, Bryce and I are in Claremont. My little car is there behind him because we met and we had some margaritas and we talked about today's session. And hopefully, we're going to be able to answer any questions that you all have. And I'm going to pass it over to Bryce. Bryce.
Hey, good morning, everyone. My name is Bryce Davis. I've been an attorney here in downtown Claremont for coming up on 10 years now, which is hard to believe. I have my practices about 50-50 estate planning and probate and contract litigation. And I randomly was in a situation where I very badly needed a notary one day. So I just hopped on Googled a notary, found Amy. And she's been great. We've been working together for a while now. I'm here to answer any questions you guys have. We got some pre-made questions. And actually I can't actually move the slide, Amy. So can we head to the first question? All right, so are online or generic estate planning forms less legally binding compared to those drafted by a specialized estate planning lawyer? Every single legal question has the same answer, and the answer is it depends. So yeah, there's actually not necessarily anything wrong with buying pre-made forms. It's just you're not necessarily going to know whether or not those forms are what's helpful to you. There's a lot of unknown unknowns if you're not well versed in estate planning. An example that I like to give with people is the Florida homestead laws are very, very tricky if you own your own home. So for example, say that you own a home, it's paid off free and clear, it's in your name. You get married 10 years after you pay off that home. You cannot devise that home away from your spouse in your will. The devise will fail. The spouse is entitled to a life estate in the home, or they're entitled to something called the elective share. And there's lots of little things like this that people aren't necessarily aware of. So while you can try to DIY it, there's going to be stuff that isn't obvious from the face of the form, and you might not be aware of it. That said, the number one thing that people mess up is the execution ceremony. That's the number one thing. That's where it goes wrong. And it's because there's, I'm sure you all have notarized estate plans. There's very specific rules for who can be a witness, whether it's an acknowledgement or an oath. And it's easy for it to go, sideways there. If, in the technically everyone's supposed to be in the room at the same time, see everyone doing the same thing. You're supposed to put them under oath. A lot of times people will kind of cut corners on that, but the analysis that you need to go through is say that one of the witnesses wasn't in the room and you had to you know, I'll go the next day and get that witness to sign it. So say that estate plan was contested. Is that person that you went to sign it the next day, are they going to testify under oath in open court that they signed it that day? They're probably not going to help you out that much. And really, this is more of a problem for the attorney or for the person doing the estate plan. Hopefully, this wouldn't be a problem for the notary, but I have definitely seen how, you know, a lot of people try to pull you guys in, try to, you know, make you give them legal advice, and you know, that's just it's something that, you know, you have to draw the line here between, you know, hey, you know, I'm just here to notarize this document. I'm not here to, you know, tell you what to do as far as your estate. And yeah, I think that's about it for that.
Perfect. So I'm going to go ahead and pass on to the next question. And my mouse, gotta love it. Here we go. Our next question is up.
Yep. And I'm just going to read these out loud because I see that some people are on their phones. So in case it's hard to read, when is it advisable for families to consider creating trust as opposed to simply planning an estate? So there's very specific, I don't know, I think there's kind of, I feel, an unnecessary push by a lot of Florida estate plan attorneys to try to make people trust, because the trust is generally a lot more lucrative. Because if I draft a trust for somebody, I'm generally charging 3 to 4 times what I would be charging them if I was just doing what I call a basic estate plan, which is last will and testament, power of attorney, and advanced healthcare directives. Yeah, a trust is usually, so you have a very rare class of client as an attorney, and that's the people that estate tax is going to be a concern for. The current estate tax exemption is almost $13 million. So for 99.999% of people, estate taxes aren't going to be a problem. I've been doing this 10 years. I think I've had one client that whole time that potentially was going to have to worry about estate taxes. So tax avoidance is one of the big reasons for a trust, but not the primary reason that most people use. The main tool for avoiding probate is a trust, and that's normally what I use them for. So in the state of Florida, there's 3 different kinds of probate administration. Probate is what takes place after the person is dead. There's what's called disposition of personal property without administration. That's for a situation where the only thing in the estate is like there's like a bank account with, you know, $1,000 in it or something. There's something called summary administration, something called formal administration. Summaries are pretty quick and easy. You know, usually it's like a couple grand in attorney's fees, and turnaround time is usually less than 6 months. Formal administration, usually much more involved. Those can take years, if not longer, depending on how complicated the estate is, if it's contested. Generally, the attorney's fees for those go to a percentage of the estate. So that's, you know, if you got a couple $1 million estate, you're having to pay the attorney 2 to 3% as a fee. That's a pretty big fee. And the specifically, most attorneys' fees are just kind of, you know, the attorneys just make it up for however much time they think it's going to take them. The probate fees actually have a statutory basis. The attorneys don't have to use the statutory basis for the attorney's fees, but they often do, because, and I do, because the reason is, in a formal probate, you have to get a judge to sign off on your fees. And if you say, Judge, I adhered to the statutory fee schedule, they're just going to sign off on it. There's not going to be any question of whether you've overcharged or anything like that. So I'm sorry, kind of getting into the weeds here, circling back. So the reason you'd want to trust is to keep yourself out of formal administration, because you can only do summary administration if the total assets in your estate, not counting the value of your Florida homestead, is under $75,000. So anything that you put into the trust doesn't count towards that $75,000 limit. So, you know, that's a good way for people that have, you know, liquid assets. Popular thing around here that I see a lot is, you know, a lot of people are in agriculture. They have farm machinery that's very expensive, that's definitely over that $75,000 limit, so they can put that into the trust. That keeps them below that. And finally, the other big reason to have a trust would be what's called a special needs trust. And that's, perhaps say, you have a family member or a child or something who has developmental disabilities. You could place income and income generating property into a special needs trust for them. And the benefit of that is if they were currently receiving Medicaid or some sort of government assistance, it wouldn't kick them off of that. So that's a way that you can ensure that people continue to get whatever you would want to leave them without messing with their government benefits. So those are basically as I see them, the three main reasons I would create a trust. To either tax avoidance, for most people, it's not a problem. Probate avoidance, that's a pretty common problem for people, or if you know somebody with special needs.
And if the person owns like two homes, so one would apply for the homestead, but then the second home, that would be the over 75.
Yes, correct. And that's the other kind of classic situation I run into a whole bunch around here. Obviously people in Florida, a lot of them are snowbirds. They have the vacation home out of state. And I always say, you want to put that other real estate into the trust, because if you don't, you're going to have to go do, if you own a house in New York or something, pass away, you're going to go have to do what's called an ancillary probate in New York. You're going to have to hire a New York probate attorney. It's going to be expensive and time consuming for your heirs. So yes, that's the other reason you'd want to put home into a trust, definitely.
Awesome, thank you. All right, so our next question.
What documents need to be filed following the completion of estate planning? Additionally, what filings are required after a death? This is a common question I get from clients. They think that I'm going to file their will immediately, and actually no, that's not how it works. After you do the estate planning, nothing gets filed with the clerk of court, except for property deeds. If you did some sort of deed, for your home, transferring ownership of that, yes, you want to file that with the clerk as soon as possible. But yeah, as far as, and also your if you have healthcare directives, you don't file them with the clerk of court, but it's a good thing to call your doctor and get those on file with your doctor. But yeah, as far as me filing something with the county or the state, that doesn't really happen until you pass away. There is a law in Florida that any will, if you're in possession of a will and the person who wrote the will passed away, you're supposed to file it with the clerk of court within 10 days of learning of their death. In practice, this almost never happens. Usually people come to me and, it's like, oh, grandma passed away, 3 or 4 months ago, and they've got the copy of the will and they have not filed it with the clerk of court. Nothing really happens to you. People, no one's going to come after you from the state and penalize you or anything like that. The only situation where that's really an issue is, say there's some sort of contested probate and somebody won't give up the will, then you can get an attorney to file a petition compelling that person to produce the will, because they haven't done it within that 10 days. But in general, the only thing getting filed after an estate planning ceremony is the property deed, if there was one. As far as what's filed after death, there is a huge amount of stuff to file after death. Most counties maintain a checklist of what is required to open a probate. And generally it's, death certificates. If it's a formal administration, you gotta get death certificates, you gotta get a whole bunch of petitions for administration, petitions for homestead, petitions for exempt property, petitions to appoint the personal representative. You have to submit a bunch of proposed orders to the judges. There's a fairly huge amount of administrative work that goes into a probate, particularly a formal administration, which is actually, I believe, why in the state of Florida, if you're doing a formal administration, you have to have an attorney. You can't do it yourself. A summary administration, you can try to do it pro se, But for formal administration, the state of Florida will require you to have an attorney, which is another good reason to try to keep stuff out of formal administration. I'm an attorney and I don't like doing formal administrations. I would rather do 10 summary administrations than one formal administration, just because it's so I hate, because you guys do a verified inventory of all these state assets. You have to do a final accounting of everything. You have to get all the beneficiaries to sign off and agree on stuff. There's usually hearings. Whereas with the summary administration, if everybody's in agreement, I never have to go to the courthouse. I just e-file the documents. Yeah, formal administration is not a good time, which is why that's why most of my estate planning is geared towards keeping people out of that and keeping them into summary, or ideally not having to do a probate whatsoever.
Awesome. Thank you. Good information. All right. Our next question.
In cases of split families, when a spouse passes away, do all assets automatically transfer to the surviving spouse, or do children also inherit a portion immediately? So if there isn't a will, everything is going to pass according to what's called the intestate statutes of Florida. And that is a messy situation to be in if you're a split family. So if there's, and again, I'm an attorney and I don't even know this off the top of my head. I'd have to spend some time reviewing the intestate statute. So if you're, say you don't have any kids, say you just have a spouse, you don't have a will, you pass away. Yeah, your spouse will be entitled to everything under the intestate laws. If your spouse is deceased and you have children with that spouse, then the children receive preference to that. So that's pretty straightforward. You still would ideally like to be in a situation where you have a will or some sort of other estate planning thing, because then you're not going to have to, for example, say that you have an IRA or a bank account or something, and it doesn't have a transfer on death designation. Well, even though your spouse or your child or whoever is entitled to that, they're still going to have to go through the probate process to get it, instead of just having to take the deed or the death certificate, to the bank or whatever, and then they would just transfer it immediately. But yeah, as far as the division of assets after one spouse, children with that spouse, it gets very, very confusing. It's like if there's like a new spouse, then they're entitled to like what's called an elective share in the estate. If there's children with the new spouse and children with the former spouse, then it gets very complicated as far as who takes what. I believe, off the top of my head, I believe it actually gets split. So yeah, if particularly if you're in a situation where like you have a blended family, it's really critical that you get everything, sorted. Because I can practically guarantee that there's going to be some sort of probate contest in that situation. That's 90% of the contested probates that I've dealt with. It's been a situation where the classic one is that either mom died or mom divorced dad. Dad is now remarried a new wife, and now dad has left everything to the new wife, and the kids are, they want their cut, and it's a bad deal. Even when there is a will in place, they're generally still going to try to contest the will, but it's a lot easier to deal with that situation than there's just nothing.
Yeah, that funny you and I know we're not really asking questions, but just wanted to share real quickly. The time that I had to go to court was exactly the situation. So this was my question because I was curious. So the hierarchy is the new spouse immediately receives everything, and then possible if the children want, it would be then contested, correct? Essentially, if there's nothing in writing. Yeah,
essentially, yeah.
So we do have a question in the chat box, but we're going to hold off. Kristen, just hold with us and we're going to get to that question at the end. Okay. So our next question.
And yeah, I'm in no rush today, so I'm happy to answer questions at the end. Could you explain the probate process, specifically the steps involved before and after a death? Yeah, I guess I kind of jumped the gun on this. I talked about that a lot last question, but yeah, generally the process is somebody dies. There's going to be the whole grieving, bereavement, funeral stage of it. From my perspective, what happens then is somebody comes to my office, they say, hey, you know, grandma passed away. She didn't have a will, or she did have a will, and here it is. As long as, you know, there's some sort of information there. All that you would really technically need to get started would be a death certificate and the little, you know, first and last name. I guess that's all in the death certificate anyway. But yeah, then you're going to have to go through the probate process I just talked about. Hopefully it was already planned out before they passed away, because then you might ideally be able to do a quick and easy summary administration, or you might be in the formal administration for the long haul there. Really the way that I do my estate plans and the way that I want it to be is I want everything. I don't want there to be a probate. I want people to just be able to, like I said, take a death certificate to the bank or the insurance company or whatever, everything's set up and it goes automatically. A lot of the times you do have to end up bringing a summary administration anyway, because sometimes there's stuff that gets caught, you know, in the cracks there. Particularly real estate is usually one. If you haven't made provisions for what happens to your Florida homestead, then you will definitely have to do a summary administration, just because you're going to have to get that property declared homestead. But yeah, generally the probate process, and I said there's misconceptions about what it's about. Like estate planning is you're alive, probate is after you're dead. So you're not really going to care about the probate. It's your heirs that are going to care about the probate. And what probate is it's a court supervised process, making sure that all the beneficiaries and all the creditors and potentially the debtors of the estate, everyone is satisfied and everything is gotten where it needs to go. Usually there are creditor issues with the states, just because people, you know, someone goes into the hospital and passes away, you know, you know, they might have like a $5,000 credit card bill or something. And this is actually an area I see like there's a lot of confusion on. So under, I guess under America law, just generally, you don't inherit debt. The estate inherits the debt. So people will come and they'll say, hey, you know, my mom passed away. She didn't have anything. The bank is sending me a credit card bill for $5,000. Do I have to pay that? And I'm like, well, you know, if there's no money in the estate, then no, like you don't have to pay that. They won't, you know, they usually won't. They're very clever with their language because they're certain ways they have to do it. But yeah, they'll try to make you think that, you know, you have to pay that. But yeah, if it was something that was only in the deceased person's name and there's nothing in the estate, nothing that's not exempt in the estate, you know, for example, say there's a house in the estate, well, that's Florida homestead, that's exempt. The only situation that you have to reach into the estate to pay exempt property is if there's a mortgage, obviously, on the house. If there's an IRS tax lien, they can take the house. Or if there's a construction lien, you know, say the decedent put on a new roof and then passed away, you do need to pay for that roof, any sort of actual improvement to the home, or they can foreclose on it. But as far as medical bills, credit card bills, if that stuff was only in the decedent's name, they cannot receive that, or at least should not.
Yeah, I'm going to share a quick story. I know that we all learn with stories, right? So my husband passed away and he forgot to put me as the beneficiary of his bank account. There's 11 cents out there that Chase will not let me close the account. 11 cents, literally 11 cents. I still once in a while get a report. There's 11 cents in his name and a Chase bank account. They will not let me close it unless I do probate, because he didn't have probate and he didn't have any other property. But on the other side of that, his credit card companies continually for 2 years, I would send them the same letter. There is nothing in his estate. He did not have any property. He did not have any assets. I would send them the death certificate, and it took me 2 years, but they finally did stop sending me, you know, you owe his debt. So yeah, I'm just letting you, we always learn from like people's stories. So thank you so much, Bryce, for like giving us this information because it's bringing back all those things. So, all right, we'll move on to our next question. And thank you again, Bryce, for your time. Learning so much.
Under what circumstances should estate planning documents be reviewed and possibly revised? The answer to that is pretty much whenever there is a major life change. So you buy or sell a home, a new child or grandchild is born, there's a divorce, anything that's, a big life event that's going to be on your radar. You move out, you move to a new state. Yeah, it's generally that's the time to have stuff reviewed and revised. And yeah, and I obviously I can't speak for every attorney in the world, but for me, it's not a big deal for me to revise estate planning documents. It's not expensive. I'll usually do what's called a codicil if it's to a will or an amendment to a trust. I've had clients come back and say, hey, we want to change the beneficiaries and blah blah blah, and it's like, sure, it's it'll be like a few $100. It's not like a thousands and thousands of dollar thing to revise your estate plan, which I think that a lot of people think it's going to be a big deal. I see Stephanie just said her father-in-law amended his trust 9 times. His attorney probably enjoyed that.
Stephanie, by the way, also is a paralegal, so she has a lot of good of her own information for this. So yeah. All right, well, thank you. And by the way, on the question before, which had to do with the probate process, so that is the family is supposed to start the process 10 days after death. Is that correct?
By Florida law, you are supposed to file, if you have it, you're supposed to file a copy, or not the copy, the original of the last will and testament with the county clerk. In practice, nobody does this. And I've never, in 10 years, I've never heard of somebody getting in trouble for not doing it. But there is a Florida statute that says you're supposed to.
Okay. All right. Thank you for answering that one. And then our next question.
What qualifies as cognitive disability in the context of legal capacity? And can individuals with such disabilities legally consent to sign documents? All right, this is a good question, especially for a notary group, because this is something where you're actually, the attorneys and the notaries are in perfect alignment on this question. So we're not mental health professionals. We aren't qualified to diagnose somebody. There's estate planning, most people put it off until they're elderly, so there's a lot of times there's cognitive decline. And yeah, basically what I do is the Florida bar has ethical guidance on this, and basically says what I just said. We're not mental health professionals, and we're not expected to be. So generally, if I can see that somebody is kind of struggling, the big tell for me is when clients come in, and it's very common for a family member to come in with a client. Mom comes in with grandma, or whatever, and I'll see the elderly person who's the client. They're doing this. They're looking at the other person before they answer any questions. So when that's happening a whole bunch, I like to try to get the elderly person alone by themselves, and then I'll ask them, is this what you want? Do you understand what you're signing today? Blah blah blah. And yeah, we're basically all that we're required to do is essentially ask them, do you understand what you're signing today? And if we're satisfied that they know what they're doing, then we can go ahead. But yeah, it's certainly a difficult decision sometimes, and there's definitely gray areas. And it's just a thing where you just have to use your best professional judgment, with the knowledge that you're not a mental health professional and you're not expected to be.
Yeah, so again, sharing my stories. Bryce can tell you this question came from me because I called him, it was about a month and a half ago. A facility here in Claremont would not release the mom to the 2 sons. because the lady, according to them, had a certain number of dementia, which I really don't even understand what that necessarily means. And yeah, so I'm like, Bryce, what can I do? They're saying that my document is invalid. So yeah, it's good to have Bryce on the phone because he helped me and walked me through that. And exactly like he said, I am not a nurse, right? I don't know. I did ask, do you know what you're signing? The lady repeated to me what she was signing. She answered my question. So I feel very comfortable that I did my job, but I lost some sleep a couple of nights there. I did 100%. All right. So my next question here is, go ahead.
What is the process and purpose of a ladybird deed? Ladybird deeds are fantastic. It's probably my favorite estate planning tool. It's really great for people that pretty much their only asset is their house. So the technical legal name for it is an enhanced life estate deed. I'm not sure why we call them ladybird deeds. I think it has something to do with Lady Bird Johnson. But anyway, what it is so there's lots of different types of property ownership. There's something called a life estate, which is you can leave a home to somebody for their life, but then it goes to the it's called the remainderman. It's whoever that you leave it to in the deed after that person. And what's notable about a normal life estate is the person who has the life estate, like they can't sell the house, they can't, they can't like destroy the house, stop paying the taxes. They basically have to take care of that house because there's somebody coming after them. A ladybird deed is an enhanced life estate deed. So what that does is you give yourself a life estate, but you don't have any of that liability. So you can sell the house, you can mortgage the house, you can take out loans on the house. You can do anything to that house that you want to do as long as you're still alive. But upon your death, it would go to whoever you named in the deed, and it would all go outside of probate. So I have lots of people that come in and they're like, hey, the only thing I got an IRA and I got my house, and that's like all that I have. Like, do you think I need a trust or something? It's like, no, you don't need that. All that you need is a ladybird deed and the basic, estate planning documents. Because yeah, once somebody, if your home has a ladybird deed, you pass away, your heirs, all that they have to do, they take your death certificate, they file it with the county, and then they own that house. And they also, and this isn't unique to ladybird deeds, this is unique to any kind of inherited property. I get this question a lot. So if you inherit a house and there's still a mortgage on that house, you're entitled to take that house according to those same terms. You don't have to requalify. You don't have to refinance it. You don't have to do any of that. It's a federal law, so it should be true in every state in the union. But yeah, if grandma passes away and she had a mortgage on her house where she was paying $1,000 a month and you inherit that house, you get to step into her shoes. And as long as you pay the $1,000 a month, you're good.
Fantastic. And I just want to again note, Ladybird is the English version of Ladybug. So I love these. We do have a quick question that I think is an easy one to answer. The difference between a quit claim deed and a Ladybird deed.
A ladybird deed could be a quit claim deed. It's just an enhanced life estate is the type of ownership. So you could say, well, maybe not up a quit claim deed. A lot of, and this is, I don't know, I think it might be like a misconception about what a quit claim deed is. I feel like a lot of people like using quit claim deeds, and I don't really understand why. There are certain situations where you want to use them, but generally not. So a warranty deed is you are, as the seller of the property, you do a warranty deed. You're saying that I warrant that I have good title to this property. And if somebody down the line, brings up a chain of title issue, I will defend my right to the title. So that's what title insurance companies want to see. I have clashed with title insurance companies in the past because they have their policies, and I'm like, well, the law is above ABC title insurance company policies. But yeah, if you're just as a practical matter, you want a warranty deed, because title insurance companies like warranty deeds, because it creates a strong chain of title. You're warranting that you have title of that property. What a quitclaim deed is you're saying that I'm not saying that I even have a claim to this property. I'm just saying whatever claim that I could have possibly had in this property, I'm stepping away from, and I'm quitting that claim to you. So I think people think it limits their liability as a seller, which I guess it kind of does. If there was a chain of title dispute later, but I mean generally the warranty deed is superior, particularly if you're if you're giving something to your heirs, your family, people that you know. I would say always do a warranty deed. That's going to make it easier. There's specific situations where you wouldn't want to, but generally that's what you want to do. Really, the only situation I can think of off the top of my head where you would want to do a quitclaim deed would be if you got divorced and you were quitclaiming your portion of the marital home to the other spouse. That's the only time that I would voluntarily choose to do a quitclaim deed. But as far as the actual mechanism of, that's actually a good question, because now that I'm actually saying it, I don't know for sure if you could do a Ladybird deed as a quitclaim deed. I would always do it as warranty deed, so I guess I need to find out in case that ever comes up.
And that's why we leave the questions to the end. I'm sorry, I threw that one at you.
Sorry.
All right, sorry, my mouse went the other way. Give me 1 second. There we go. Next one.
Are family members permitted to act as witnesses in estate planning documents? And the answer to this is yes and no. It depends on what type of document it is. So, for example, healthcare directives, so like healthcare surrogacy, living will, that doesn't have to be notarized. It needs 2 witnesses, but the witnesses can't, at least one of the witnesses, no, none of the witnesses can be your spouse or blood relative. Power of attorney, none of the witnesses can be the agent. So it can be your family members, but it can't be the person that you name as the agent. Last will and testament, people are usually surprised to learn that, yeah, you can witness wills even if you're beneficiaries of the wills or your family members. It's not best practice. The best practice is to, in any situation, is to always have 2 neutral witnesses. That's the best practice. It's going to cut down on any sort of contest. But sometimes you're in a situation where you're going to have the beneficiaries be the witnesses. Sure, if you're witnessing a power of attorney, witnesses, they got to be 18 years old, they got to be of sound mind, they can't be the agent. You cannot witness a power of attorney that names you as the agent. But yeah, neutral witness is definitely best practice.
And now
POA can be family. Just not if the family member is the agent, then no.
Yeah, I blanket say no. That way there's, when I have the option, that is, right? Like when I have the option as a notary, I blanket say no. But sometimes I had a situation that I explained to Bryce literally 2 days ago where I didn't have a choice. So, all right, next one.
Is there a legal preference or requirement for stapling or not stapling estate planning documents? Yeah, kind of it could just be me being paranoid, but it's a minor thing with me. I never ever staple my stuff, because the reason is it's going to get scanned, it's going to get taken out. One of the legally operative ways in Florida to destroy a will is by ripping it up. So and I've had wills come in that obviously it had been stapled, removed, and to the point where there were big, rips in the paper. And I had one that was so defaced that it was actually the physical destruction of the paper was actually bleeding into the writing. Fortunately, all the heirs and beneficiaries were in agreement So there was no issue with that. But if somebody had contested that, I think they could have had a good argument that that will was defaced.
Yeah. I get that question all the time from my clients about stapling and all of that. So thank you for that.
For a medical healthcare directive, which option is typically recommended to check for the effective date, either or both? Healthcare medical directives, I just have them go into effect immediately, because the reason for that is the document only becomes, unless you specify otherwise in the document, the default provision is it will kick in when that person becomes unable to make their own decisions. So yeah, in my healthcare directives, I generally do not specify a start date, because that's what we want. We don't want it to kick in until that person is unable to make their own healthcare decisions. Now, a financial POA is gonna, unless you put an effective date in it, it kicks in immediately. So people are kind of surprised to learn that. And I always, usually my advice to that is, people that are naming like their children or whatever, but they're still in good health. I'm like, maybe you don't tell your kid that you named them POA, because if you do, they could sell your house tomorrow and you would have no legal recourse.
Yeah. You always say this too, like if you don't trust the person that you're putting as the POA, then don't put them as a POA. So yeah. Interesting. So I just want to I have a clarifying question real quick, Bryce, about the witnesses. So I want to make sure that I put my notes correctly. For the medical healthcare directive, should not be spouse or blood, right?
Yeah, no spouse, no blood relation.
For the POA, cannot be the agent.
Correct.
And then for the last will and testament, yes, it can be family.
It can be beneficiaries, can be family. It's not the best practice, but it can be.
Yeah. So my advice for us notaries is say no, right? Say no, please get two independent, or let me get them for you. This is what I always do. Like if you're having struggling getting not family members, let me get them for you for a bargain price. So there you go. All right. So the next one.
Do you have any additional advice for families, business owners, or notaries regarding estate planning? I think I've pretty much covered my high points. I'll just reiterate once again that it's so much better to plan it before it gets to the probate process. And I don't know why people have such resistance to it. It's very strange to me, and it's normally not people with who are in dire financial straits. It's usually very wealthy people. It's people with millions in their bank, and they'll be like, oh, I don't want to pay to have this. And it's like, well, you're going to pay 3% of your estate to a lawyer, or I guess your heirs will later on. But yeah, it's just, I think it's just something that it's better to get it taken care of as young as you possibly can. If you're if you're somebody that needs, because this is another thing that people I think have kind of a misconception about, is the amount of money you have really doesn't have any bearing on how complicated your estate planning can be. I've had $5 million estates that were easy, because the only thing that was in them was like a house and some bank accounts. And there was like one marriage and one surviving kid. That's easy to plan. I've had other estates where there was less than $500,000 in the estate, and were just absolutely crazy to plan, because there were multiple spouses, multiple children, people were scattered across the country, like all out of state. So yeah, you can end up having an extremely complex estate, and it's not really based on the amount of money in the estate. It's just based on the family relationships. And I refer people all the time, if you're somebody who doesn't have the spare change to do it, there's lots of pro bono legal aid organizations that'll help you. I know in Lake County, we do Lake and Orange County does like estate planning clinics. semi-frequently, where, you know, if you qualify, people can come and they'll do like a basic estate plan for you. I think Amy just did Wills for Heroes over in Orlando. But yeah, it's definitely something to take care of while you're still alive, because if you're dead, you're not going to be too much help.
Yeah, so just letting you know, we have about 3 or 4 of the notaries that were there that day in our session. So we're very invested. We're very invested. All right. And then Stephanie is the one that brought it to us, by the way. I always want to give her credit because I don't want it to seem like it was me. So, all right. So just letting you know the order of the questions for everybody, including Bryce. So we had these lists of about 11 questions. And then when I advertised, hey, these are the 11 questions we had some more come in. So even though I know you just gave advice, technically that was the last one, but then we have these new ones that came in after, okay?
What are the legal ramifications if a witness is improperly sworn in during the signing of estate planning documents? Right, so this is kind of a nuts and bolts thing. But it could end up being very important one day. So pretty much every single attorney in the state of Florida, when we do estate planning documents, we're going to have something on there called the self-proving affidavit, and it's always there. But really, it technically isn't part of the will. It's a completely separate document. What the self-proving affidavit is doing is it's the testator and the witnesses all swearing that they just signed the will. And so what that allows you to do is then you can just, hey, you know, when you go into the probate process, all right, I'm filing this will, self-proving affidavit. All right, court says, boom, will admitted to probate. So technically, if you didn't do that, you could just have a will that 2 witnesses and the testator signed it. That's a valid will. But when you went to probate it, you would have to find those witnesses. Those witnesses would have to come to court or execute. It depends on the judge. Some judges make them actually come in and testify. Some are okay if you just execute an affidavit. But the short of it is if you don't have that self-proven affidavit, or you mess up the improperly sworn in stuff, you're going to have to find the witnesses. The witnesses are going to have to swear under oath in some capacity. Yes, I remember on such and such a date, I came and witnessed, you know, Joe Schmo signed his will. So it's not necessarily catastrophic, but it does create a big problem if you don't have it.
100%. So again, adding my stories to all of these questions. Literally 2 days ago, I had to kind of push back on a lawyer who added a codicil to a trust and a codicil to the will, and said that I could do a self-proving affidavit, attestation of myself. And I'm like, ma'am, I can't swear myself in. I cannot do it. So I'm so sorry, but I cannot. I have to push back. This is not something that I can legally do. So just letting you know, sometimes the lawyers out there might not necessarily know our job, right? They know their job, but they might not necessarily know our job. So just be careful, because yeah, you don't want to have a situation where because you were kind of pushed into doing something, you have now messed up whatever it is that they were trying to do. So just FYI. All right. And then we have a couple more questions, if I'm not mistaken. I think we have like maybe 3 or 4 more.
But just to add on to what Amy just said, yeah, don't be afraid to push back on the lawyers at all. And I've told Amy this is one of the things. This is why I keep using her over and over. Something I really like about her is she's not afraid. You know, she'll say, "Well, hey, you know, should we do this or that?" And she's corrected me a few times. And if you're a good attorney, you're okay with that. It's like some lawyers get this attitude of, oh, you know, how dare a notary, you know, tell me what to do. But no, that's not how it should be. Your concern as the attorney should be for the client. You want to get their stuff right. So if they're a good attorney, in my opinion, they will welcome corrections or clarifications. Is there a preferred ink color, blue versus black, for signing official estate planning documents? Yes, always use blue ink, please, please. Blue ink is what shows it's an original document. So, and again, this is kind of like the self-proving affidavit. It's not necessarily a fatal, catastrophic thing. It's just a major inconvenience thing. If you don't have the blue ink original, all you have is a black ink copy, then you're going to have to do the thing where you have to find the witnesses and they have to testify that this is actually the will. And on that same note, I always tell clients, you know, when we finish, please put this in a bank safety deposit box, put it in a fireproof safe. Don't just chuck it in a drawer somewhere, because you will need to find, well, not you, because you'll be dead, but your heirs will need the blue ink.
Facts. Okay, so that was actually it. I thought we had some more questions. So let me go back real quickly. I am going to go back real quickly. Give me 1 second. I'm going to get to our parking lot because we do have a question from Kristen S. So just give me 1 second before I open up. So Kristen, you can either go to the mic, or I'm happy to spell out the question that you had added there. Would you like me to?
Can you hear me?
Yes, perfect.
Hi. Yeah, and it might be easier. So I was just reading, you know, about ladybird deeds, and in the article, it actually just like surfaced up a couple weeks ago. It was stating, you know, adding a child like a ladybird deed could actually, you know, potentially cause some issues for your child down the line. One was student loans. Another was it's considered an asset. So, you know, if they don't claim that, that can be used against them in certain circumstances. So I was like, not to get TMI, but my daughter may be looking into buying a home sometime this year, next year. So I just want to make sure, what potential issues could there be by adding her, because she's already on the deed as a ladybird?
Yeah, legally there shouldn't be any asset reporting or anything like that. And the reason for that is because if it's a properly drafted ladybird deed, what the remainder men have is, it's called an unvested interest. So she has a potential interest, but it's not vested, meaning it's not something that should apply to her. Now, could there potentially be, you know, some private company out there that tries to you know, maybe they run a public record search and they say, oh, like, we see you are on this house, why didn't you report it? But legally, that to me has no effect, because it's an unvested interest. She doesn't have the right to do anything as long as you're
until
still
I
alive.
die. Yeah. Okay, got it. All right. So the article kind of scared me. I'm like, oh, do I need to take her off? You know, so okay.
So I do have another 4 questions that were brought by one of our people here. So I'm going to have Kristen pick up the mic, and Kristen K, go ahead and ask your question while I go we do have 4 more questions that I guess I just didn't add to the presentation. So I'm going to go find them. So Kristen K, can you please pick up the mic? Go ahead and ask Bryce.
Can you hear me?
Mm-hmm.
All right. Hey, Bryce, it's Kristen, and I just have a question. In 2018, I took a trip to Europe, and primarily to Rome. And I thought, I don't have anything in place. What if I just disappear off the streets? So I did a very simple will through legalzoom.com. And I'm a homeowner, and I have some investments. And of course, I went through everything. I was working with an online attorney, blah, blah, finished everything. In fact, I think my medical directive does have, like, first my brother and then my sister-in-law, which I know you said something about it shouldn't be blood or spouse. He is an allowed
witness
anyway, but the witness. Now I had I took it to, I had it all drafted up, and it said, well, you have to take it to a notary. So I went into the office on my day off, and one of my coworkers is a notary, and she notarized everything for me. And I took it to, and then I have it. And then also there was something mentioned about, and this is the big question is, do I need more than that?
I mean,
I signed something so that if I disappeared or whatever, okay, it's going to go into probate, but the home, in order to be able to list it, sell it, take the profits from it or whatever, I spent like an extra $100 or something with the clerk of the court in Seminole County and filed this special something or other. And I'm so sorry I didn't look it up before I talked to you, but it's supposed to keep that part of the process out of probate.
Yeah, I got no idea what that could be.
Okay. No problem. You know, if I'm not here, I'm not going to worry about it. But here's the question. Do you think someone like me needs something more than that? I don't have any other dependents. I mean, there's just me.
Yeah. I mean, the
'Cause
official
everybody's
legal
like, you need a
answer.
living, you need a revocable living trust. And I'm like, put everything in a trust. And everybody's trust now. And I'm like, what?
Yeah, I mean the official answer is I can't really tell you unless I actually like read your documents because I
Yeah.
don't know what's in there.
Sure.
I mean, yeah, generally, like I said, the only time you're gonna need the trust is the three, you know, you got over $13 million, so you're worried about estate tax, you're worried about formal administration, or you have somebody who has special needs. Yeah, like I said, attorneys definitely, I think, push the trust a little too
Yes.
much just because I
Yes.
said it's so much more lucrative.
So these were the questions. If we can answer some of these.
And thank you, by the way, for answering that.
Absolutely.
So, okay.
Thanks,
And
Kristen.
I might reach out to you and just have you review what I have.
Yeah, sure.
For a fee basis, of course. Thank you so much, Bryce. Talk to you, Amy.
Thank you, Kristen. And sorry, I might not be grammatically correct because I just popped them on there. So just FYI. So that's the estate planning agents or
Okay. I was like, what's an EPA?
we
Okay.
love our acronyms as
Yeah.
notaries,
Yeah.
okay?
All right. Do estate planning attorneys already have a set notary fee structure they pay out? I mean, I pretty much just pay whatever you guys ask me. I know that it's statutorily, it's $10 a signature, I believe, is the statutory thing, and you're also allowed to charge a little travel fee on top of that. So
Yeah, it's the travel fee, but it's also your expertise. So here is the situation where you're not just paying for the travel and you're as a notary, right? Not Bryce. This is not Bryce's opinion. This is Amy's opinion. You're also paying or charging, I should say, for your expertise, right? So that the lawyer that you're going to go visit is going to know that you're going to do the things correctly, that you are going to put the witnesses and the signers under oath, that you are doing your part. So my fee to Bryce fluctuates depending on the complexity, how many times I was required to sign, how many identifications I was required to authenticate, those kinds of things. So it really does vary, right? And again, this is not Bryce's opinion, this is Amy's opinion. I'm going to make sure that he's in the clear.
I will also say, just as far as notary fees, something that's really important for attorneys. So, Amy, I know that you offer the service that you can have witnesses appear. Attorneys, big no for us. We cannot pay a witness money for witnessing because that then casts the authenticity of the document into question, and it's an ethical violation. So it's fine for you to charge a witness fee, but just don't tell me or any other attorney that you're charging a witness fee. Just, you know, roll it into the travel fee or something like that. Yeah.
I didn't know that.
Yeah.
All right. I'm sorry. My mouse is acting crazy. So I'm trying to get it back on the page so that it can move the page over, but it doesn't seem to want to. So let's try. Here we go. Yes, this is the next one.
I mean, I think you could probably answer this better than me. I mean, as far as me, I call the notary. I don't know how other attorneys do it. The way that I like to do it is I have the table set up. I print out all the documents, sit the clients down, and Amy's heard me make the joke 20 times. I mean, it's not really a joke, it's an observation. I'm like, man, there has to be like an easier way to do this. But yes, it's always just a nightmare of, you know, going through the documents, and then you got to double and triple check everything. And this was something that Amy did that I really liked, that a lot of notaries I had used in the past, like they just kind of like sit there and let me, you know, hand them the stuff. Like she was very active and like helping me double and triple check the documents and collate and everything. It's just small stuff like that is really huge, because I'm trying to think of all, okay, like is witness good and is all this other stuff right? So it's just very helpful to have someone there helping you with the administrative side of it.
Yeah, and you'll get into a swing, right? Like whether you're doing for a client themselves or with a lawyer. And the story that I was telling you about, the lawyer that I had to do a little bit of pushback on, that person had me they sent me the documents, I had to print the documents, I had to scan the documents. So each service is slightly different, right? I had to go find the witnesses. So literally each service that you're providing is different. So that's going to fluctuate on how you handle the documents, you know? So just kind of keep that in mind. The next question.
Are there any specific requirements or qualifications you look for in notaries you may want to work with? Really the most important thing to me is, like I said, someone who's going to be more active and just kind of like the administrative stuff, you know, helping me double check those documents, collate everything. That's helpful. You know, just like good personality, someone who can, you know, build a rapport with the clients and make the clients feel welcome. It's kind of creepy when it's someone just kind of like sitting in the corner and they're not, you know, really engaging with anybody. So I mean, yeah, there's not to diminish, you know, there is a lot of legal stuff that, you know, notaries have to know and you guys have to do correctly, but there also is a big customer service aspect to that I think is, in my experience, that's more of the weak point that I see with notaries, more so than, you know, not knowing the procedures.
Good to know. Thank you. All right. Next.
How often do you need notary services and is there a peak season? Me, I'm doing, I don't know. It depends on the month, but yeah, on a good month, I'm probably doing somewhere between 5 to 10 execution ceremonies, and the peak season for estate planning I find is definitely right after the holidays, like January, February. That's when everybody's coming in. Kind of, you know, it'll dry up a little bit after that usually, but yeah, post holiday is the estate planning rush.
Holidays like Christmas holidays, or what kind of holidays?
Yeah,
Any.
just, you know, yeah, Thanksgiving, Christmas, Hanukkah, all that stuff right there. New Year's at the end of the year. So yeah, it's like once people are back to work, you know, usually around mid-January, that's when people start coming in more for estate planning.
That's a good question. I hadn't thought about asking that.
Where can a notarization take place? I mean, it can take place anywhere as long as you got the witnesses and all the documents you need. I would love if I could do more of my notarizations remotely, but many of my estate planning clients, they're elderly, you know, they don't have smartphones or they're not comfortable with it. So unfortunately, for the foreseeable future, it's looking like it's all going to be in person. Oh, I was tangentially related to this. I was gonna say, be careful with depending on the counties you practice in, review their procedures for accepting documents, because there's apparently I can't remember if it was you that told me this or not, Amy, but there's apparently a county in Florida that will not take e-signed deeds.
Oh, I didn't know that.
Oh,
No,
was it you? Okay,
I
yeah,
haven't had any. Yeah, I haven't had any issues with any of my runs, but I do know that New York does not like them, Nevada does not like them, and Virginia. So those are the three states that I know prefer, not that it makes it less legal to do it, you know, to do a run in the state of Florida, but they just do not like them. They will try to push back on the person that did it in an electronic way to get it done with what they call wet ink. So yeah.
I remember now, it was another attorney I was talking to about this. Yeah, it was a county up by the Panhandle, and yeah, they blanket refusal. They'll just reject runs. Has to be wet ink. Yeah,
It's interesting. That's a good thing to know, right? Like especially us Rons here. So does anybody have any questions? I did the chat box closed up when I went to go look for those other questions. So let me make sure we didn't miss anything. Your time is important. So I know we've gone a little bit over. I just want to also make sure your questions are important, that I didn't miss anything. I think I got everything. And yes, so let me go ahead and give you, again, I will be sending this, I'm going to send it in a PDF, and I'm going to send you a folder with the note-taking questions and also his contact information, but I'm going to go back to that slide so that you can take his contact information. real quickly so that you have that. Here you go. So his phone number is 352-577-8740. He's wonderful. I send people to him all the time. So just letting you know. And again, to kind of wrap up, I do appreciate your time. As you know, I do these as a community thing. I want to help the people that I know in my circle that are kind of struggling with the same things, right? So I'm opening up the people that I know that have helped me get to where I'm at, and Bryce is definitely one of those people. I will be sending out this presentation with a recording and a little summary, and then my contact information is here too. So if you needed to get a hold of me or anything at all, I am here for you all. So I am the founder of Ladybug Mobile Notary Services and also of the Small Business and Notary Work Get Together Hubs. I love my long names. Love my long names. Thank you so much to everybody. I am so grateful to you all for having spent a little bit of Saturday with us. And if you need anything at all, you know where to find us.
Thank you, everyone.
I'll go ahead and turn the recording off. And I know there were some people that wanted to find out